Guys, update concerning Nnamdi Kanu'S case today, 22nd of May 2025. Let's watch the video and know how it goes. Stay tuned for more updates.
Welcome to the deep dive.
Great to be here.
So today we're jumping into some very specific source material. We've got excerpts from a court update for the trial of Mazi Nnamdi Kanu, specifically from May 22nd, 2025.
That's right. And our mission really is just to unpack what happened in court on that single day. We're going to look at the key moments, the testimony we have details on, what the judge directed.
So it's like a snapshot, a really focused look at one section of this ongoing legal process, sticking strictly to what's in our sources.
Exactly. No speculation, just the reported facts from that day.
Okay, let's dive in. Where should we start? Maybe with the judge's tone for the day.
Good idea. Because the judge really set the pace right at the start on May 22nd. He made a significant decision.
Which was?
He stated quite clearly that he was placing the case on what he called accelerated hearing.
Accelerated hearing, so speeding things up considerably.
Absolutely. And he gave his reasons, said he wanted the case closed in a timely way, pointed to how long the defendant's been in detention, and also, mentioned the court's upcoming vacation playing a role.
Okay, practical reasons too. But the timeline he set, that sounds incredibly tight.
Oh, it was. Our sources quote him saying, I give you 6 days to present all your witnesses, even if they are 500. 6 days total.
Wow, 6 days for all witnesses, regardless of number. That is intense.
It really is. It signals a very strong push from the bench to get this done. And he did add that human touch, didn't he? Reminding everyone.
Yeah, remember, a human being is still in detention and away from his loved ones. Puts it in perspective.
It does, but make no mistake, the warning that came with it was just as strong.
What was the consequence for not meeting that deadline?
He was explicit. If either side failed to stick to that 6-day duration, their case would be closed, done. And that accelerated hearing decision, that would stand. No extensions.
Okay, so the pressure was definitely on.
Massively.
Right.
So with that framework established, the court then turned back to the ongoing business, which was the cross-examination of the second masked witness.
Ah, yes, the masked witnesses. So this was a continuation from before.
Exactly. And the defense counsel seemed to really focus on, well, questioning the witness's actual knowledge base and the investigation itself.
How did they start that?
They kicked off asking about the defendant's international passport, whether the witness had custody of it.
And the response?
Simple. I don't know.
Okay, not a detailed start.
Not really. Then they asked about the defendant's travel history. The witness could only say, he told me he has been to many countries. Sort of hearsay, almost.
Right. And what about that broadcast mention? Did the witness know where it was made?
Nope. Same answer, I don't know.
Interesting pattern. Did it continue?
It did. The questioning got more specific about the investigation. The defense asked, did you get a statement from Mazi Nnamdi Kanu after that letter from the former attorney general?
And let me guess.
Well, slightly different this time. I didn't get any statement and I didn't see any. So still a negative on direct involvement there.
Okay, what about an investigation report? Surely the witness had one.
They asked that, do you have a report? The witness said yes.
Ah, okay. Finally, something concrete.
Well, then the defense asked to see it. The witness replied, I don't have it here. It's in custody of the federal government.
Ah, so exists maybe, but not available in court from this witness.
Exactly. And that's where the defense really pushed. They basically said, hold on, you didn't investigate the defendant yourself, you didn't get a statement, but you're here as a witness.
That's a direct challenge. How did the witness respond to that?
With a pretty surprising statement, actually. The witness said the investigation is immaterial.
Immaterial. An investigator saying the investigation is immaterial. That's something.
It raised eyebrows, you could say. The defense kept pressing, did you investigate or video anyone specific to this case? Witness says, I made investigation with some people. Vague again.
And their own report on that?
Same answer, I don't have it. This lack of sort of tangible proof from the witness's own actions seemed to be the core point the defense was hammering.
Makes sense. What else did they challenge the witness on?
They moved to the video evidence the prosecution had shown earlier, asked if the witness saw anyone carrying arms in one video.
What did the witness say to that?
It was a bit ambiguous. I don't know. Arms can be concealed.
So, not a yes or no. Did they identify anyone in the videos?
The witness said, I identified ESN, the Eastern Security Network, but then admitted they couldn't identify any individual faces personally.
So identifying the group, but not the people in it.
Correct. Then the defense shifted gears a bit. They brought up the hashtag #EndSARS protest.
Okay, how did that fit in?
They asked the witness what hashtag #EndSARS was about. Our sources say the witness actually paused then, didn't answer immediately.
Interesting. Did the defense capitalize on that pause?
They did. The counsel moved to submit a new document, the report from the Lagos State Panel of Inquiry that investigated events after hashtag #EndSARS.
And the judge allowed it.
Yes, approved it, marked it as an exhibit the defense could use.
So how did they use it immediately?
Straight back to the witness. Asked if they were aware that this official hashtag #EndSARS report did not indict IPOB.
And the witness's response?
I am not aware.
Okay. So the cross-examination covered quite a bit of ground. Any other key points?
Yeah, a few more. They asked how long the defendant was in the witness's custody. The answer was vague again. I met him in June. I don't know how long he has been in our custody.
Right.
Also confirmed they didn't personally reply to that letter from the former Attorney General and weren't aware if any formal report went back to the AGF.
And what about recordings? The prosecution often relies on recordings, right?
The defense asked about that. Do you have recordings of people saying the defendant told them to commit crimes?
Let me guess.
Witness said, I don't have. Other witnesses will bring it. Pushing it off again.
So this witness didn't have that specific evidence.
Seemed to be the point. The defense also got the witness to agree that before IPOB was prescribed, it wasn't illegal, and its members aren't criminals unless they commit crimes.
Which sounds logical.
Right. But then the defense asked, well, if you're an investigator, why didn't you investigate the members who were criminals?
Good question. The response.
Bluntly, I didn't do any investigation.
Wow. Okay. That seems quite damaging to their role as an investigator in this specific context.
It certainly highlights limitations. They finished that part by getting the witness to agree it's the government's job to provide security.
And did the witness think the government had done that?
They said, yes, to the best of my ability. A slightly qualified yes.
Okay, so now the defense shifted again, right? To the actual impact of things the defendant allegedly said.
Exactly. They asked for proof that things attributed to the defendant, like the sit-at-home orders, were actually happening because of him.
How did the witness handle that?
It was a personal anecdote, not really evidence. The witness said, I live in Abuja. There's no sit-at-home here. If I live in the East, I will still come out on Monday.
So basically avoiding the question of whether it was happening elsewhere and why?
Pretty much. Then they asked, do you know anyone who actually wrote their will because the defendant supposedly told people to? Witness, no, I don't.
Okay. What about evidence of anyone carrying out other alleged threats?
Witness was unsure. I am not so sure.
So the defense jumped on that uncertainty.
Yes, they suggested this lack of proof meant the threats were ineffective. The witness just responded, I don't know.
This pattern of I don't know or I'm not sure is really prominent.
It definitely is. And that's when the defense brought out their own exhibit, a flash drive.
Ah, the flash drive with videos. This links back to the previous day, right?
Correct. They'd asked the witness about recognizing their director general on video. So now they presented this flash drive. The judge accepted it, marked it as an exhibit.
Okay, so things are getting interesting. Did they play the videos?
Defense counsel asked to play it. Judge said yes. But then the prosecution, led by San Awomolo, objected.
On what grounds?
They claimed the person in the video about to be played wasn't the director general.
But how could they know before it was played and the witness asked?
Good point. The judge seemed to agree. He overruled the objection, saying, look, it's not my job to ID the DG, it's the witness's job.
Right.
And the defense lawyer clarified, hey, I haven't even asked the witness who this person is yet, so the objection was premature.
Okay, so the videos finally played. What was on them?
First clip showed a man talking to people, saying, and this is a quote, if you are depending on the police for protection, you will all die.
Strong words. What did the defense ask the witness?
Is that your director general? Witness said no.
Okay. What was the next clip?
Different man, also addressing people, saying things like, everyone must come together to fight Boko Haram and restore peace, and it's impossible to leave the fight for security agents alone. And crucially, he calls for everyone to defend themselves, and the time to start it is now.
Another call for self-defense. Did the witness know this person?
Yes. Said it was the governor of Imo State, Hope Uzodinma.
Hope Uzodinma. Okay. And the defense connected this back.
Immediately. Reminded the witness that just the day before, they had testified that this same governor, Uzodinma, had accused IPOB of killings in Orlu.
Right, I remember that.
So the defense asked, did you hear the governor is now saying those killings were by the opposition party?
Implying a contradiction or shifting blame, what did the witness say?
Kind of deflected. The governor did not mention names.
Interesting. Was there a third video?
Yes. Played the clip, then the defense asked who it was. Witness identified the speaker as T.Y. Danjuma.
Another high-profile figure. What did he say in the clip?
Defense asked, did you hear him say waiting for police protection means death? Witness confirmed, yes.
Okay. Did the defense ask for comment?
They did. Asked the witness for their take on Danjuma's statement. Shut that down. It's not my job to interpret his statement.
Fair enough, maybe. But did they follow up?
Yes. Asked if T.Y. Danjuma said everyone should carry arms. Witness again confirmed, yes.
And the key question then?
Exactly. Did your agency arrest T.Y. Danjuma for saying that?
Yeah.
Witness, I am not aware.
So the defense is clearly drawing parallels, suggesting maybe a double standard in how such statements are treated.
That seems to be the strategy, yes. Comparing calls for self-defense or arming oneself from different figures.
How did the cross-examination wrap up?
Just a couple more points. Ask the difference between Amotekun, the regional security group, and ESN.
And the distinction according to the witness.
Purely legal. Amotekun is recognized by law, but ESN is not.
Okay.
And one final question. Linking back to Governor Uzodima's video comments about politicians and killings, defense asked, is IPOB into politics?
The answer.
I am not sure. And with that, the second witness's cross-examination finally ended.
That was a lot of I don't know and I'm not sure. Quite a detailed look at how evidence is challenged.
Definitely. But the day wasn't over. They brought in the third masked witness.
Ready for the next round?
Apparently not. As soon as the third witness came in, the prosecution objected. Said their own witness wasn't ready for cross-examination.
Their own witness wasn't ready. After the judge's big speech about accelerated hearings, how did that go down?
About as well as you'd expect. The judge, according to the sources, was having none of it. Immediately reminded them, no going back on the accelerated hearing.
Did he just tell them to get ready then?
More than that, he ordered the lawyers, both sides, to pick 6 straight days, right there and then, to finish the case.
Wow. Put them on the spot.
And he issued a serious warning. Said if they couldn't sort the dates and stick to it, he'd consider striking out the case. And then he apparently called the prosecution weak for not being ready.
Called them weak. That's strong language from a judge.
Very strong. He added, we cannot continue like this, reduce your witnesses so this matter can end soon. Basically telling them to streamline their case because they weren't prepared.
So did they manage to agree on dates under that pressure?
Yes. After some deliberation between the prosecution and defense teams, they managed to set the schedule.
Which dates did they land on?
They set aside May 28th and 29th, so just a few days later. And then 4 dates in June, the 6th, 16th, 18th, and 19th. All in 2025, of course. That's the 6-day window.
Okay, so the judge's push worked. The dates are locked in.
Seems so. The matter was formally adjourned to those specific dates.
Right, let's quickly recap what we covered from this May 22nd session. It started with the judge setting that very strict accelerated timeline.
Yeah, 6 days total, driven by the defendant's detention time and the court schedule, with that firm warning about delays.
Then we had the detailed cross-examination of the second masked witness. Lots of challenges from the defense about the witness's actual knowledge, the missing reports.
And questioning the real-world impact of the alleged statements. Lots of I don't know responses.
Plus, those key exhibits came in the #NSARS panel report from the defense, and those defense videos with figures like Governor Uzodima and T.Y. Danjuma making statements about self-defense.
Right, used to draw those comparisons and challenge the prosecution's narrative.
And it all culminated in that moment with the third witness, where the prosecution said they weren't ready.
Leading to that strong reaction from the judge, calling the prosecution weak and forcing them to set those 6 specific dates in May and June to wrap things up.
So you've really got an inside look at the mechanics of this trial on one specific, quite dramatic day. You see the back and forth, the challenges, the evidence presented or not presented.
And all under this intense pressure from the court to move things along quickly.
So here's something to think about, based just on what we saw from this one day. When you have a witness, especially one presented as an investigator, who repeatedly can't provide specifics, doesn't have their own reports handy, or says, I don't know, to key questions during cross-examination, what does that practically do to the weight of their testimony in the eyes of the court? Or even just in understanding the case, it really makes you question the foundation, doesn't it?
It certainly raises questions about how strong that particular piece of the puzzle is for the side presenting it. Definitely something to keep in mind as the trial continues on those newly scheduled dates.